I know it's been a lot of a forced march, but I hope you think that it's been well worth it. The discussions I heard as I went in all the rooms were absolutely fantastic. And in this panel, which my colleague Lisa Rohrer is going to moderate, we're going to hear reports from the ones you weren't able to be in, a little bit about what happened and what our moderators thought about what happened. So let me turn it over to Lisa Rohrer.
Great. Well, thank you. It's been a great day, David. Thank you for putting it together. So as David said, we are now going to try to share the knowledge that we got in our individual working groups with the entire group so that we can all benefit from these different areas of innovation. And I think we're going to start with Elizabeth Chambliss, who's writing furiously about her takeaways. Elizabeth, you want to
I have 3 words. This is going to be pretty extemporaneous. So I actually want to tell a quick little story. So we had a research roundtable on limited licensing at the University of South Carolina last week, and in trying to bone up on limited licensing for the roundtable, I was doing some research, and I came across a New York Times article from 1971, and the headline was, "Educators Fear Paralawyer Proposal." And it was complete deja vu. It was everything that's happening on the limited licensing side of things except in 1971. And it struck me that although that's about the paraprofessionals and sort of innovations in different career streams, that there's a certain amount of paradigm tension, at least for me, when I come to conferences like this. I can imagine 3 futures. One future, and this is the access to justice for low and middle income consumers. We've been talking about it. Really, you can find quotes from 1920, 1930. They always say the same thing. Nothing ever happens, or at least nothing ever changes about the access problem. So one future is nothing ever changes. The ABA doesn't adopt regulatory reforms, or the ABA doesn't promote and states don't adopt regulatory reforms. We have conferences like this every 10 years. The people change. They all imagine they're discovering the problem, and technology and technological advances don't really make a big difference. That's one future. The other future, which I keep anticipating because of the people I've been hanging out with lately, is that suddenly the whole world is turned upside down by the 3rd stage of computing and information technology, and law schools and law firms go up in poofs, and it's a completely new world, and change comes from outside the profession, and we're disrupted into oblivion except for very high margin work by global corporate lawyers like you I study here. And then the third possibility, or maybe a stage along the way to disruption, is what it seemed to me that Chris Kenny was talking about a bit today in his talk about organic change and sort of lawyers working with technology to do not seemingly hugely radical things, but things that over time advance the ball and create space for innovation. So, applied to our panel, I got this list coming off of the limited license conference that we had. And when I first read the blurbs, I thought, this is supposed to be about access to legal services and knowledge, but really all of these businesses are for lawyers. So there's knowledge management for lawyers and helping law students study better and professors work with them to study better, and having lawyer-annotated search engines, and it was very lawyer-centric. But then in hearing people talk about their business models and their business plans, I realized that the blurbs didn't fully represent what they were up to, and that there were certain downstream and sort of third-party benefits to the lawyer-centric focus of most of the startups or businesses here. So I found myself struggling to think about how to put them into a theme, and I guess I came up with, for myself, that whatever the future is, there's clearly a space where lawyers can work more closely with technological entrepreneurs to improve what's happening, at least incrementally now. And so whatever else is going on, you're safe in the collaborative space. So when in doubt, praise the forum. So I think events like this actually are very helpful, because I've met people who are affecting my thinking. Everyone's meeting other people, and that there's sort of a brokerage function that needs to happen right now, whatever you believe the future to be, between people in mainly traditional law and people mainly outside of traditional law. And just as a final sort of comment on the panel, I'll say something that I also said in our working group, that I was struck A couple weeks ago, I have a middle school child. She had an event. I had to miss reInvent Law in New York, which I very much wanted to go to, but I had to go to my kid's event. So it turns out the same day was the ABA mid-year meeting where there was a lot of discussion about the future of the profession. And as I sat in a really crappy North Charleston hotel listening to a bunch of sixth graders sing, which was great, I thought, isn't it ironic that the ABA mid-year meeting on the future of the profession and engaging with technologists is the exact same day in a different city as reInvent Law New York, where all the startups and technologists were meeting with lawyers. And that seems to me to epitomize what we should try and stay away from, and that we need to sort of get those meetings and those people to be talking to each other. And however optimistic or pessimistic you are about innovation and the delivery of legal services to low and middle income individuals, that can't be a bad step. And so the sweet spot of lawyers, working directly with lawyers who have incentives to benefit their own business but have either direct or third-party benefits, is at least one possible way to get at least organic change. So that was the theme I took out.
Ron?
Well, it's been kind of hard to organize all of this into one coherent thing. I asked a few questions. We were looking at what were the barriers to adopting innovation, let's say, within law firms. I also asked them if their products or services were wildly successful, what would that do to the legal system? And also, I didn't quite get a chance to ask about measuring quality of product, and in particular when we were looking at things like document automation software, where you're doing grammar checking or you're merging documents together. We don't want to just increase efficiency at the cost of destroying quality. So what you see, for example, in a lot of cases with e-discovery or with online dispute resolution is when you increase the efficiency, you tend to increase the quality as well, but it's worth measuring. So when I asked about barriers, the responses included different aspects depending on the firm size, and the attitude of lawyers wanting to avoid risk. Also, just a comment about, well, they just don't want to change because they're, and then when you get set doing something, you don't want to just pick up a new product. Also, just a typical problem of larger firms where there's just too many cooks, and which practice group or whether it's the IT group or whatever that would have to facilitate the incorporation of a new product. There was no argument given, though, that people really didn't want to increase efficiency, which was nice because we've seen a shift over the last, 5 years about efficiency mattering now as a competitive edge even within large firms. So nobody is sitting there saying, well, we heard a little bit of that, the occasional comment that it hurts my billable hours if I'm more efficient, but for the most part, that's not much of a stated problem. When we started talking about success, what happens if some of these products were wildly successful, then the impact would be, for example, that lawyers would enjoy lawyering more because they're not doing as much of the mundane work that they can't stand doing regardless of what they're getting paid for. The clients would like their attorneys more because the work happens faster, maybe the quality goes up. One of the quotes was a more polished product with less effort. So let's see what else I can come out with this. And then we had 3 of the startups that were at my session were looking at document related, and one was looking at online dispute resolution. More time?
That's fine. You've got lots of time.
Okay, sorry. And so, we did have a little bit of a discussion about the nature of, or the role of documents in the legal system. And to what degree is a document, that set of writings that we want versus different versions of contracts as having, for example, embedded software where, and this was at a talk from last year at Stanford Future Law where some startup was talking about embedding procurement rules within the contract, right? So that the contract really, if you want to see what's binding, it's more likely going to be the software that's embedded rather than the words. So what you agreed to is that I'm shipping this product because that's what entered into my procurement system, and that's what I'm going to give you, and that's where I get a notification if it stops working. So we start looking at contracts differently, and that starts moving us in the direction of real innovation rather than, as some people were saying, not just making more efficient the existing processes that we go through, but looking at revamping the processes completely. So what I didn't really get much, and for quality, what I did manage to ask about was, it came up with Modria and the dispute resolution, that quality, for example, can be measured as the number of disputes per transaction. So you have some metric there to see if the system is working, and it's interesting to think about what quality means across the legal system for brief writing or for discovery, et cetera. And you want to figure out certain metrics that you can use so as you increase automation, you know that you're not just destroying the quality of what you're doing. The last thing I would say is that we didn't really get a chance to start drilling down into where the pain points are for a practitioner. So that's what I would really like to start finding out from a design perspective. What are the things that practitioners really hate? Where would we really like to see change? How much of that is coming out of, let's say, ethics rules? How much is that coming out of billable hour related? And to see where we can really start injecting innovation that would not have the barriers to adoption. So that's okay.
Great, thank you. Marty?
Hi, I'm Marty Mazzoni from Fidelity Investments, and I had the pleasure of moderating the Innovations in Legal and Analytics and Big Data session, which was terrific. We had 4 terrific presenters. I will give you a little bit of demographics. One presenter was from Brazil, and the other 3 were from Silicon Valley. So, they were all men, which I hope does not represent in any way anything about any trend in the disruptive innovation world. And they were all youthful, which I guess is probably not a big surprise. And a couple of the comments that were made, I just thought some of them were fun. Big law should be afraid of us. I liked that one. Search is about the long tail, which we'll talk a little bit about. So it was a great discussion. We talked about the problem. Well, we talked about innovation in a set of functions that have to be effective in order to cope with the vast amount of data that is out there. Search innovation, analysis innovation, and really content access. If I were to sort of put the conversations into 3 different buckets. In search innovation, we heard some really interesting, I guess, I don't think proprietary ideas out there, one of which was that searching in the old-fashioned way that results in a list is not necessarily very helpful anymore, and certainly not to maybe a younger population that is expecting more from its search results, and that guidance in navigating what comes up in a search is going to be an important technology in the law. Visualization as part of your search is going to be an important part of technology in the law. It already is in e-discovery, and certainly it is in fraud detection and some of the surveillance technologies that are out there. And so some of these vendors are thinking about visualization in legal research as well. There was a big emphasis on analysis and how quickly computers can work versus people. A brief discussion, which we didn't really have time to flesh out, about the claims of accuracy that are made by all of these tools and all of these disruptive innovators, and my personal skepticism about those accuracy claims, not because I don't think that they can be accurate, but because I don't think the data is there really to support the claims of accuracy that are made, and this is a particular problem in the predictive coding world and the e-discovery world. We also had, one of the presenters talked about the concept of searching and getting beyond the things that always come up, and really using searching techniques and the searching engines that they're developing in legal research to get much deeper into the research. All of the presenters, I believe, one of the businesses we looked at was a trademark business, but the other three were talking about big data in terms of case law. So that was interesting because, first of all, that's probably the big data, quote unquote, that people have access to. They don't have access necessarily to more the way I thought of big data, what we were going to be talking about with big data, which is the more general data that's out there on all of us. So it was, much of what we looked at was about cutting into the legal research market and doing legal research differently, and coming up with, one of the companies calls it the, I believe, the legal genome. And actually being able to articulate, to parse out what's happening across all of these millions of cases, let's say in California, and come up with a genome, a pattern for what's happening in the law in California. So that was very interesting to me, but one of the people who questioned that said, you know, that's a pretty small part of what lawyers do. And I actually think that's true. I'm an in-house practitioner and happen to be a litigator, so I'm really a facts lady. I'm all about the facts. I'd like to see these tools be broadened, to think more broadly about what do we really need as litigators. Case research and legal genomes will be undoubtedly helpful. It's a very tiny part of what constitutes a pain point for clients and for lawyers, and it's certainly a small part of the cost of outside counsel. And I can quote you chapter and verse on that. So I'd like to see that. Another thing that I would like to see is to have this kind of thinking about search innovation and analysis innovation applied to internal information governance in corporations. So again, that's my bias. I'm an in-house counsel. Our company probably has 4,000 or 5,000 systems of some kind in order to operate our many lines of business. As I tell my clients internally, every single system we have is a record-keeping system and is a source of evidence. And I'd love to see, you know, these kinds of innovations that people were showing somehow built into some kind of an integrated approach, federated approach maybe to the systems that are out there, the hundreds of thousands of systems that are out there, proprietary and, you know, marketed systems that businesses are using to store records, and really kind of blowing up the idea. We heard a lot of good ideas. I felt that they were somewhat constrained by a kind of old-fashioned idea of what it means to be a lawyer. We're still thinking about the lawyer who's writing the brief to the Supreme Court and how do they get the research, but that's not how most of us practice law or what most of us really need help with. We also had a very, and I'll close with this, we had a very interesting, and there was one other theme I wanted to say was content access. One of the people who was there asked the question, which I thought was an excellent one, which was, do you think about your customers maybe not being lawyers and maybe being just people, the public, and actually using some of these search capabilities and analysis capabilities to figure out problems for themselves without a lawyer in the midst? Now, she didn't say it quite like that, but I interpreted it that way. Very good question, I thought. I mean, what's the ultimate disruption? Not needing a lawyer anymore is the ultimate disruption, right? And I know that wouldn't make most of us happy, but nevertheless. And then finally, I would just say that on the same point of thinking about how do you get these kinds of innovations working against data about us and what good you could do with that. One of the people who was in the room, who's a judge, asked the question about using these kinds of tools for jury selection and for or I should say for gathering information about jurors in order to make informed jury selection choices, and pointed out that there's a financial inequity often in the cases that he sits on, and in all cases that, you know, people who can afford jury consultants can use data to make better data-driven decisions about their jurors. And couldn't you envision this kind of a tool, that one of the tools that we looked at, being used in much the same way? So really broadening the idea of what it means to be disruptive in the practice of law. I would say, I just would conclude, I guess, that it's great to be thinking about search and analysis of case law, but the real effects, I think, would come in getting into all of the data that's out there about all of us. Thank you.
Thank you. So in our group, we looked at really more the business side of the legal profession and between law firms and clients, and we were looking at issues around pricing and matching. And you know, I guess one thing that struck me from our group was two of the three, we had just three, two of the three companies were really trying to make life easier for smaller firms or for solo practitioners, or they were trying to make life easier for smaller legal departments by providing tools that were otherwise inaccessible to them. And in that sense, really looking at a different part of the market in a very Clayton Christensen way, I think, is looking at parts of the market where the big players are not very interested in playing. And so, and in fact, two of the three were doing that, and the third one wanted to be there, but quickly found that they were being adopted by large firms, which was interesting as well. So that was one thing that we noticed. In terms of the larger trends, so what people were doing in our group, first of all, were matching solo practitioners with legal needs. Secondly, providing a way for law firms to allow their clients to see billing data in real time as it was being recorded into the time and billing system. And the third startup is really around helping the smaller departments to analyze their legal spend. And so I think all three of these companies were building on some larger trends. Certainly cloud-based computing and analytics, and we were talking about how similar your session must have been to ours, but now in listening to you, I'm realizing that that's analytics about substantive legal, and we were really on the business side, so I think that was the major distinction there. A lot of interest in transparency of information and trying to open up the kimono a little bit, both on the pricing side and on the matching side to help, you know, make those matches better. And interestingly, also picking up on changing trends in the labor force. So the interest in many younger professionals to work independently and have more control over their work. And so taking advantage of some of those macro trends we saw in all of the startups. So let's see. We talked a little bit in this world, particularly when you're up against big, say, e-billers, for instance, is how do you get noticed? And how do you actually get your foot in the door? And one of the people in the group remarked that it's actually much harder to sell efficiencies than it is to sell revenue. So it is a real challenge for them. One startup talked about how they have had a lot of success really identifying some influential people and getting them interested in their product so that they could go out and really evangelize about it. Others talked about really looking at where the headaches are and trying to address those headaches that people see in the legal profession from the business side. So those were some of the things that we talked about. And we also got into a very interesting discussion about, okay, well, these are good innovations and important and helping a lot of people, but at some level, are we just addressing the symptoms of the problem here in the legal profession? in the sense that the billable hour, if the billable hour were to go away, as one of these startups admitted, they wouldn't have a business model anymore, at least as it currently stands. And so, and the lack of transparency is another thing. So, so there was a question about, and we sort of batted around a little bit about, are we part of, are we just addressing symptoms, or are we doing something more fundamental? And of course, there were differences in opinions about that. And then finally, we then talked a lot about just challenges of innovating in this space in general, and I'm sure that everybody in the other sessions discussed the challenges of the partnership model and how that can make it harder to invest in new technologies, although again, there are differences in opinions. Certainly we're seeing in some large law firms, we are seeing some investment in some new ways of doing legal services. The question is, is it, how widespread is it? How fundamental is it? And so we talked a lot about that. And just, the industry is ripe for innovation, but how far will it go and who will be pushing it? So it was a great discussion. All right. Yeah, so we have some time for questions from the audience or reactions. Again, we would ask that you just come to the microphone so that the streaming can pick you up and we can all hear you as well. Oh, and he's just the sound guy. So yes, please, thank you.
Thank you so much for reporting what happened in the other room. I was here. My name is Aminu. I'm a lawyer, and I am a doctoral student. I work with David Wilkins. I want to know if in the conversation there is any discussion as to the distinction between innovation and imitation, because for some countries, actually what may pass as innovation is actually an imitation of something that is going on elsewhere. So what we have in some cases is just disruptive imitation, instances where technologies are transferred from one jurisdiction to another. So I want you to just respond to that, and in what way, if any, that is really affecting the incentive for innovation generally. Thank you.
Anybody want to take that, Ron?
I like to joke that we're trying to bring the law into the 20th century. So if we are so lucky as to imitate other sectors, we would be doing fine. So if you look at the way doctors are working with diagnosis, with increased tools, or electronic medical records, or the way the billing might be handled, or payments, I think we could do a lot from borrowing from various sectors. Certainly there's room for just straight out innovation in those areas where law is unique. But I think right now we are so behind the curve that imitating successes elsewhere would bring us into the last century.
I agree. Which would be great. We didn't talk about innovation and imitation. That's very clever. But it's sort of to my point earlier. I feel like there's still this constraint, even among the interesting and innovative people that spoke with in our group. It still feels constrained. It still doesn't feel like it's a big enough idea. And there's an industry. There's a big legal tech industry out there that wasn't, of course, represented in my group. But big data is the big thing right now, and there's a lot of big ideas around big data. And as good as the work seemed to be that was happening, the big idea didn't come out to me. And I'm not sure if I would call that imitation, but I would call it a little bit. It's sort of how much of this is driven by the money that's been invested in the scope and. I would have liked to have seen a bigger creative picture than I saw.
Yeah, it's constrained. I mean, we have, ethics rules regulating the way that, if being online and being on an online marketplace means that you're breaking advertising rules or whatever the constraints are. So we haven't yet been able to bust open the level of innovation that I think is appropriate for what law could be. We can see it where there's private stuff, for example, in contracts. Perhaps we can see bigger changes coming because there's no rules somehow breaking that. And there's systems that are willing to adopt, let's say, embedded software within a contract structure. But so certain areas we're just really still constrained, and I have a feeling that once that change happens, it will accelerate really quickly. So.
I actually did raise that with my panel because, as I said before, I initially thought these seemed like making lawyers better and happier, and how did that get us to more access for clients? But I don't know if it was Jake or Tony. One of I think it was Jake said, successful startups tend to begin because somebody's trying to solve their own problem, and then it gets taken out. And then Tony, I think you reminded me that it's not inherent in the technology how disruptive it is, and I think the gentleman's question actually indicates that what's innovative in one market may be old hat in another market, and so I'm not sure if it's inherent, if any of these qualities are inherent in the things that we're looking at or in their deployment. And so it takes me again back to the question about how the mechanisms and process of change are going to look: slow and steady, disruptive, and that's probably different in different segments of the market, I would imagine.
And I would say on the business side, there's definitely a lot of imitation of what's being successful in other industries, but I think that probably goes without saying. So, yes.
I have a question for the panel. I want you to imagine a new world. The new world is that there is no limitation within a legal practice on the talent that you can have in your practice. And imagine, let's say, 5 years from now, that you could have 20% of the people, the professionals in the law firm are actually technology people in the firm. So my question is, what would they do? How could they be adding value to clients? And to make it a little relevant in Deloitte, that's exactly our strategy in our tax practice. We're seeing governments change the way they interact with taxpayers. And we see the use of data really being fundamental. So rather than recruiting as many accountants and people with legal training, et cetera, we're going to change our proportion and recruit a lot more, STEM people, science, technology, engineering, math people, into our business, because we think it's going to be much more, the business that we're in is going to be much more data-driven. So if there was no limitation in a legal practice, and you could have technology people, not that you hire or provide you a service or optimize the way you do legal research, but you could have them in your firm. What are some ideas about what you might do with them?
Well, I think we already see that. I don't think that that's a constraint, actually. I mean, Fidelity brought all discovery in-house years ago. We don't spend almost a dime on discovery with outside counsel because we brought in, and I built a team of technologists, I built a team of project managers, I hired an actual process engineer, I actually put a Six Sigma black belt process engineer in my legal department. We have business analysts, we have information security specialists. We built an entire team of people, and then we started with the people, then we built out all of the processes, and then we built proprietary workflow technology using, of course, it's Fidelity, we're lucky we have some resources, to do that. Not every company can do that, but I think we're already there in some parts of the law. We're already, well beyond a pure lawyer model. And it absolutely can be done with transactional work, that same kind of unbundling of the type of work that has to be done and aligning it with different professions. You could do exactly the same thing with transactional work and probably many other types of legal work.
So one example that I know of is from Seyfarth, where they have an engineering team, Seyfarth and Shaw, and there were some client problems about the delivery of information related to trademark infringement, and they sent engineers over, and they managed to get that sent out to the lawyers within a few hours to the mobile device, got it done, sent right back to the law firm. So it went from perhaps slipping or several weeks to a few hours and done. That was done by the law firm. So a law firm that is more of a consulting and or technology-based firm as a full solution would look to see for their clients, what are your technical problems that are getting in the way of your risk and or legal problems, and let's go fix it together. It's a mindset change that isn't just, like, okay. But you can also imagine, even for consumer law, like as we worked with Fidelity actually at the design school, so I have to talk to you. What do you need to do for client-facing in order, for example, to get enough information to offer a tiered fixed price? So I want enough information from you, the consumer, but I don't want to burden you too much. There's design issues in there, and there's engineering problems in there. And how do we pass information back and forth in a kind of a mass market way? So now what we're also looking at is, well, law firms typically are handling, let's say, corporate or individualized stuff, and they're not yet used to really moving out into solving consumer-wide mass legal problems. And I think that's going to change too. Lots of room for legal tech, and you need that cross-training of engineering, design. Some examples that come to mind.
Nixon Peabody has a whole project management team now, and they're lawyers, but they're also project managers. They're trained in project management. They could build a house,
Is that answering some of what you're asking?
Perfectly.
Okay.
Thank you.
Thank you.
Thank you. Kevin.
Hi, I'm Kevin Colangelo. I go to a lot of these events, and this has been a really great day so far, and thought popped into my head during our session with Ron. I think the profession itself has a marketing problem, a massive marketing problem. The industry has its own marketing problem as it relates to consumers, and I've heard a lot more today about consumers than I have in a long time, and I'm feeling good about that, although I don't have any solutions, and I've not really had much of a skin in the game in my big law career. But as it relates to the profession, I wondered if any of your groups discussed how to market better to the next generation of lawyers. Not necessarily a huge problem here at Harvard, but I think there was a study out a couple of weeks ago. I don't remember the exact number, a dozen or 2 dozen law schools had 30% drop in enrollment in the last 4 or 5 years. How do we get students to come into the profession who are, let's pass by the confirmation bias of the traditional law student, find people who want to learn project management or lean processes, who want to learn how to code, who have better business skills. It's a huge element of the legal profession right now, is lawyers just aren't very good business people. Did anyone discuss that in any of your sessions about how we kind of start attracting that next generation, the people who are going to carry us in 2020 and 2030?
Well, I think in our session we talked a little bit about that, which is really this rise of the independent professional and people that are really more interested in working outside of traditional organizational structures. And that is to give them a platform so that they can actually have a practice and find a way to meet up with clients in a more efficient way than just cold calls and cold emails. So that was one thing that's happening on the matching side, is to actually facilitate that between people that are, and it does tend to be younger folks, I think, that are very interested in working more independently. So that was one.
Yeah, we didn't talk about it, but I would say, people are interested in working, period, right? So if, whether they want to be project managers or they want to, write briefs to the Supreme Court, what is the market for? What's the market out there for? And I'm a buyer of those outside counsel services, and I don't, there are 500 people within 1 mile of this location right now who can write a good brief to the Supreme Court, and there are probably 5 people who can manage a document review cost effectively. Seriously, I'm totally serious, right? So I'm, it seems to me that law schools should be paying attention and telling students what they need to know and what they need to be good at in order to get the jobs.
So some issues that we didn't talk about this per se in this, but I certainly has. And so first of all, we're trying to do cross-training, but cross-training, let's say through design, engineering, and law, also means that we want to have career paths for people. So the decrease right now is because there's not a lot of jobs easily available to them, or they don't, we can't match the needed clients. Okay. But there's a lot of stuff that needs to happen, so we have to start training them. But in training them, we also have to make sure that these job paths are opening up. So we have to bring the companies and the law firms and everybody together. So we do like these free design workshops, and we bring in engineers, designers, lawyers, and practitioners, et cetera, and we start looking at what we could be doing. And we end up with some designs. And who wants to take these designs forward? And the next step is to start doing some, let's say, startup launch pads, or to start reaching out to these companies and say, look, you need a legal tech in-house because you're doing all this stuff inefficiently. So let's start hiring these people. So it's a combination of doing the training and getting the job paths opened up and stuff like this to make sure that that awareness of the changing profession is there. Also, we have issues. How much does, for certification, are you allowed to do non-law classes? And what's considered to be a non-law class? Because if somebody wants to take an undergraduate programming class, that might count against them in terms of their law school credit, and we need to start looking at that as well. So, okay.
I just want to echo that. We talked a little bit about the marketing issue in my group, but my group was made up of 4 entrepreneurs, all of whom were all in on the law tech cross-training. I was looking around for Richard because I don't see him right this second, but one thing he mentioned, I know Stephanie's here too, part of what they've done is vertical integration and set up their own educational training program to try to actually educate people to do the kind of stuff that they're trying to create in the world. But I know from the experience I've had at various law schools and also talking to people, it's really hard to get students to take those courses. They're worried enough about their regular jobs and they're thinking some funky tech thing. What are you talking? I mean, like, unless you're at Stanford, where everyone seems to get the value proposition. But I think it's hard. Law schools, even where they're supportive of new courses, and it's not clear where those jobs are, and students really, I think, are insecure about branching out into some wacky, and I know people who've invested in expert systems training and law, and they're unemployed. So I do think there's a career track part that we're either going to have to help create or launch entrepreneurially.
Just a last comment on that. I was at an event earlier in the week, and I guess the COO of one of the largest, maybe the largest legal department in the world came out to me and said, hey, do you know anybody who has experience in pricing analysis in a law firm? And I said, yeah, I know about 10 people who are all fully employed. I assume you have a position. Yeah, we need somebody who's worked in a law firm. That person doesn't exist. They're actually gainfully employed and probably being overpaid at a law firm, and one of the world's largest legal departments can't find that skill set. They're probably going to have to go outside and maybe go to a Deloitte or somebody to find that skill set. So it is very challenging right now.
Okay. Anyone else? Any other questions? Okay. All right. Thank you.
What we're going to do, we have our last panel, actually, we just start having some people come in who haven't been here before. So what I'd like people to do is stand in place or talk around, but don't leave the room. Because it's like, so I'm waiting for my dean to arrive. We've got a hookup video for Richard Susskind. And I think Tom Sager actually just walked in here. So we're going to move to have the new panel up here. We're going to start as close to 4:30 as we can. So, talk amongst yourselves, and we'll be back. But please first thank the moderators who did a fantastic job. Thank you. Thank you.
Can we leave it?